All right, welcome in everyone to our deep dive today. Going to be talking Henry Schein, Inc. v. Archer and White Sails, Inc.
Schein versus Archer and White Sails.
Yeah. So this one, gets into some pretty fundamental questions about arbitration. When you agreed to have an arbitrator decide whether a dispute can even be arbitrated, is there any way for a court to kind of step in at the beginning and say, hold on a second, this is so clearly not something for arbitration that we're not even going to send it there?
Right. It's getting at that question of, how much power does a court have to look at the merits of the case in that very initial stage before it even goes to arbitration?
Exactly.
Is there any kind of safety valve there, or are the courts really just hands off once the parties have agreed to arbitrate, at least in theory?
Right. And this case really, boils down to a disagreement about the role of courts when you have what's called a delegation clause in an arbitration agreement.
Yeah, those delegation clauses, they're basically saying, hey, we, the parties, we agree that the arbitrator, not a judge, is going to decide if our dispute even falls under this arbitration agreement.
Right. So it's almost like a mini agreement within the bigger agreement.
Right. You're agreeing to arbitrate the very question of whether you should be arbitrating.
Exactly. So, the petitioners in this case, they really planted their flag on the Federal Arbitration Act, the FAA.
Yeah, the FAA. It's kind of the bedrock of arbitration law in the U.S.
Absolutely. And they were pointing to, specifically sections 2, 3, and 4 of the FAA. And they said, look, these sections are pretty clear. Courts have to enforce these agreements according to their terms. And a delegation clause is just another term, right? It's part of the deal.
Yeah, they were taking a very textualist approach.
Right. Just reading the plain language of the statute.
Exactly. And their argument was that once a court sees a valid delegation clause, meaning it's clear the parties agreed to it and a party's trying to fight that, the court's job is done. It's the arbitrator's turn to figure out if the issue even belongs in arbitration in the first place.
Right. They really hammered this idea that the court's role is super limited in those situations. Now, one of the key arguments that came up a lot was this idea of a wholly groundless exception. Some lower courts had recognized this idea, but the petitioners here said, nope, you won't find that anywhere in the FAA.
Yeah, they were pushing back against this idea that a court could say, well, even though you agreed to let the arbitrator decide, this claim is so out there, so baseless, so ridiculous that we're not even going to let it get that far.
Right.
It's interesting, too, because while it wasn't the main focus of the Supreme Court's questions, there's this whole other layer to delegation that comes from the rules of arbitration organizations, like the American Arbitration Association or AAA.
Oh, yeah. Those rules play a big role in a lot of arbitration agreements.
Definitely. And the petitioners pointed out that often agreements will specifically say they're incorporating those AAA rules, and those rules themselves give the arbitrator the power to decide arbitrability. Right. So their argument was basically, look, by agreeing to use these rules, the parties already clearly delegated that decision, clearly and unmistakably as the legal standard goes.
It just kind of bakes it into the agreement right from the start.
Exactly. But on the other side, the justices, they really wanted to explore what happens if you follow that argument to its logical end. They were throwing out some pretty wild hypotheticals, like what if someone files a claim based on instructions they claim came from aliens on Mars? Or a dispute about who owns Crimea comes up in a contract about construction work that has nothing to do with Crimea.
Those were some interesting hypotheticals for sure.
Yeah. And the point they were driving at was, are we really going to force people into these expensive, time-consuming arbitration proceedings just to decide if something can be arbitrated when it's so obviously not related to the agreement at all?
Right. It's what's the point of even going through that process?
Right. And to their credit, the petitioners' lawyers did offer some responses to those scenarios.
Yeah, they didn't shy away from those tough questions.
Not at all. They said, look, even if something totally bogus ends up in front of the arbitrator, there are ways to deal with that. They talked about the possibility of the arbitrator imposing sanctions, kind of like a penalty for bringing a frivolous claim.
Yeah.
And they also suggested that maybe a court could step in after the arbitration is over if the decision is truly outrageous.
But that kind of gets into some tricky territory, right? How much power does a court actually have to review what an arbitrator decides?
Yeah, that's a whole other debate. Generally, courts are supposed to give a lot of deference to arbitration awards. They're not supposed to second guess the arbitrator unless there's something really seriously wrong with the decision.
Okay.
So it's not clear those safeguards would really be enough in those extreme cases that justices were talking about.
Okay, so let's flip sides now and look at how the respondents' lawyers approached this whole thing. They focused a lot on Section 4 of the FAA, the part that talks about a failure to comply therewith, with the arbitration agreement.
Right. And they were saying that this language actually gives courts a specific job to do to act as a gatekeeper.
Okay, so not just rubber stamping everything that comes their way.
Exactly. They argued that a court has to look at a claim and say, is there a real dispute here about whether this should be arbitrated, or is it just crystal clear that this has no business being in arbitration? And if it's the latter, then filing the case in court isn't actually a failure to comply with the agreement, it's just common sense.
It's like you're not failing to comply if you're saying, hey, this doesn't even belong here.
Right. And they also tried to draw a distinction between their argument and what the Supreme Court said in the Rent-A-Center case. Rent-A-Center said if you're specifically challenging the delegation clause itself, that has to go to the court. But the respondent here said that doesn't mean courts can never look at the underlying claim at all, especially if it's so wildly out of bounds.
So they're saying Rent-A-Center doesn't shut the door completely on courts having some role?
Right. And they also brought up the Stolt-Nielsen case, where the Supreme Court did intervene in an arbitration decision because the arbitrator had basically gone rogue. There was only one outcome that made any sense under the agreement. So they were using that to say, look, there are times when courts do step in, even with arbitration.
So they were building a case that this wouldn't be completely unprecedented. But even with all that, there was this one big question that kept coming up, and it was, how do you actually define wholly groundless? Like, where do you draw the line between a claim that's just incorrect, maybe a little weak, and one that's so utterly baseless that it should never see the light of day in arbitration?
Right. Trying to come up with a clear standard that everyone can apply consistently, that's tough.
Yeah. And the justices themselves seem to be struggling with this, trying to figure out how you'd actually make that distinction in practice. And they were also worried that if you try to create this exception, it could actually make things more complicated, leading to more litigation right at the beginning as parties fight over whether a claim meets that wholly groundless standard.
Right. It could undermine the whole point of arbitration, which is supposed to be faster and more efficient.
Exactly. Now, the respondent also made an interesting argument about, what did the parties actually intend when they signed this agreement? And their point was, it's hard to imagine anyone would actually agree to go through this whole arbitration process, which can be pretty expensive and time-consuming just to decide if something can be arbitrated when it's so blindingly obvious that it shouldn't be.
Yeah, did they really contemplate that scenario when they signed on the dotted line?
Right. And they said a wholly groundless exception would actually be more in line with what the parties probably intended. And they also tied it back to general principles of contract law, which generally require parties to act in good faith. And since the FAA says arbitration agreements should be treated like any other contract, they argued that courts should be able to step in and toss out those frivolous claims just like they can in regular contract cases.
So they were trying to show how this exception wouldn't be some radical departure from existing contract law.
Right. It would just be applying those same basic principles to arbitration. So this case really gets to the heart of how we think about the FAA and how we balance the general preference for enforcing arbitration agreements with the need to prevent the system from being abused, used for claims that are so out there they're basically meaningless. And how the Supreme Court decides this will have a huge impact on how arbitration works in practice.
No doubt. It'll affect how those agreements are written, how they're interpreted by courts, and how much power courts have to act as a check on the process.
Exactly. If they say there is a wholly groundless exception, it could help stop those truly frivolous claims from clogging up the system. But it might also open the door to more legal fights early on, as we discussed. And if they say there is an exception, it could make things more efficient at the start, but then there's the worry about people being forced into arbitration for claims that are completely nonsensical.
It's a tough balancing act. And, thinking about this from a 10th chair perspective, if I were on the Supreme Court, I think I would vote to affirm what the Court of Appeals did, which was to recognize that narrow, wholly groundless exception.
Interesting. So tell me more about the reasoning behind that hypothetical vote.
Well, it really comes down to the idea that there are limits to what people can actually consent to in a contract, right?
Right.
You can agree to have an arbitrator decide whether a dispute is arbitrable, But that agreement can't cover every single possible claim under the sun, especially those claims that are so detached from reality or the actual agreement that no reasonable arbitrator could ever say they belong in arbitration. Like imagine those really far-fetched examples the justices brought up, the Martian instructions or the ownership of Crimea in a totally unrelated contract. Those are the kinds of scenarios where I think it makes sense to say, look, this is not a legitimate dispute over arbitrability, and the parties couldn't have intended to delegate something like this.
So it's not about giving courts free rein to decide what should or shouldn't be arbitrated, but about those very specific situations where the claim itself is just like nonsensical on its face.
Exactly. It would be a very limited safety valve to prevent the system from being used for purposes that are just so obviously outside the bounds of what arbitration is supposed to be for. And I think it's important to emphasize this. This wouldn't give courts the power to just jump into the merits of the dispute at the beginning. It would only apply in those rare cases where the claim that something is arbitrable is so ridiculous that it shouldn't even get past the starting gate.
So it's really about preserving the core idea of arbitration while acknowledging that there might be these very extreme edge cases that need a different approach.
Exactly. And I think this aligns with the overall goal of the FAA, which is to promote efficient dispute resolution. Sending a clearly non-arbitrable claim to arbitration just wastes everyone's time and money. It makes a lot more sense to just nip it in the bud at the beginning.
And how would you say this kind of narrow exception fits into the bigger picture of how we understand delegation clauses and arbitration agreements?
I think it refines the way we think about delegation by saying there's an implied limit based on what a legitimate arbitrability dispute actually is. We're still upholding the strong presumption in favor of enforcing those agreements, but we're also recognizing that there are these very limited situations where that presumption doesn't make sense, where the claim of arbitrability is so off base that it's hard to believe the parties ever intended to delegate something like that.
So it's really about drawing a line in the sand, saying there's a limit to what delegation can encompass.
Right. And it strikes a balance between the need to enforce agreements and the need to protect the integrity of the arbitration process itself.
Well, as we've seen, the Supreme Court's decision in Henry Schein, Inc. v. Archer and White Sales, Inc. is going to have a big impact on how all this plays out. It'll clarify whether this wholly groundless exception exists, and if so, how narrowly it will be applied.
And the court's interpretation of what constitutes clear and unmistakable evidence of an agreement to delegate arbitrability will be important too, especially when those agreements rely on incorporating the rules of organizations like the AAA.
Absolutely. So for all our listeners out there, we encourage you to think about these issues and how you see them playing out. What stood out to you in this case? What arguments did you find most persuasive?
It's a really fascinating area of law, and the Supreme Court's decision will have a lasting impact on how businesses and individuals navigate the world of arbitration.
And just a reminder, our deep dive here is for informational purposes only. This isn't legal advice, and it doesn't represent the actual views of the Supreme Court or predict how they'll ultimately rule.
Right. It's all about exploring these complex legal issues and hopefully giving you some food for thought.
All right, well, thanks for joining us for this deep dive into Henry Schein, Inc. v. Archer, and White Sales, Inc. We'll be back soon with more insights into the latest Supreme Court cases.
Until then, keep those legal minds sharp.